Welcome, everybody. Thank you for joining us for tonight's Adult Issues webinar series, webinar number 2, on Turning 18, Guardianship, Entitlements, and Waiting Lists. My name is Jill Harris, and I'm the Clinical Liaison at the New Jersey Autism Center of Excellence, also known as NJACE. NJACE is a statewide, innovative, comprehensive, and collaborative network to promote quality research, professional training, and to build public awareness aimed to improve the lives of individuals with autism across the lifespan. The center is funded by a grant from the New Jersey Governor's Council for Medical Research and Treatment of Autism to Rutgers State University of New Jersey, with partnership from Children's Specialized Hospital. To learn more about NJACE, resources, and goals, please visit our website at www.njace.us. The goal of the Adult Issues webinar series is to build understanding and skills of people with ASD, from transition to adulthood and throughout the lifespan. The series is intended for adults with autism, families, friends, service providers, and the general community. Topics and experts were chosen based on input from various stakeholders, including autistic adults, caregivers, and providers. Some things to remember as we continue. On the right side of your browser, you'll see a chat box that might look something like this. In order to participate in the YouTube live chat, you must sign into your Google or YouTube account. Here is what the sign-in button looks like for both desktop and mobile YouTube clients. Once you click on that button, YouTube should redirect you to the appropriate login page, and afterward will redirect you back to the live stream where you can now chat and ask questions to our presenter. As time permits, the presenter will address your questions at the end of the presentation. Tonight's webinar is being recorded, and the recording of this webinar will be provided on our website under the Resources, Webinars by NJACE tab very soon. Please check back in a few days for the recording and feel free to share with anyone. We will also be putting a webinar evaluation link on the YouTube live chat box for participants to complete. The evaluations will help us gauge interest and topics for future webinars, so please fill them out. The evaluation is also on our website under the Resources, Webinars by NJACE tab for you to complete there if you prefer. With that, we're pleased to welcome our speaker for tonight, Adam Wilson of Hinkle, Fingles, Pryor, and Fisher. Adam is well-versed in all areas of disability law. He has a demonstrated commitment to representing underserved populations and served as a student director of the Rutgers University School of Law Street Law Pro Bono program, providing free legal rights education to youth in Camden, New Jersey. In addition, he worked as a student attorney in the Rutgers Immigrant Justice Clinic and was managing editor on the Rutgers Journal of Law and Public Policy. Prior to his work at Hinkle, Fingles, and Pryor, Adam served as a judicial intern with the Philadelphia Court of Common Pleas. Adam holds 2 undergraduate degrees from Pennsylvania State University, graduating with high honors. He graduated cum laude from Rutgers School of Law in Camden. Adam frequently lectures on a variety of disability-related legal topics. He is admitted to practice in New Jersey and Pennsylvania and is a member of the Elder and Disability Law section of the New Jersey Bar Association.
Okay, thank you very much for that introduction. As you just heard, I'm Adam Wilson. I'm with the law firm Hinkle, Fingles, Pryor, and Fisher, and I'll be talking today about transitioning to adult life. Ooh, we got some wonderful effects on this PowerPoint slide. And let's break right into it, starting with guardianship. So, as you can see on the screen, guardianship is a way to protect an individual who is not able to make decisions for themselves. And essentially it's a way for a court to appoint someone else as responsible for making an individual's decisions. So the primary goal of guardianship is protection. You're protecting someone from themselves. The guardianship process often comes up with adults that have developmental disabilities. So when a child turns 18, they are considered totally emancipated from their parents' control from the legal perspective. And essentially that means that parents that have been taking care of their child for 18 years and in many cases making every decision for that child, no longer have the legal authority to make those decisions. In order to get to legal authority, you have to make an application to a court, and I'll be describing exactly how you do that. But before we get to that, the first question that you have is, when is guardianship appropriate? Is it appropriate for my child? Because there are many individuals that have developmental disabilities that don't need a guardian. And the essential question, you see the legal standard there, and like many legal standards, it is not particularly helpful. It's if someone is unable to govern themselves and manage their own affairs, then guardianship is appropriate. What courts are really looking towards are the ability to make major life decisions. So we're talking about medical decisions, financial decisions, legal decisions, occupational decisions, where to work, and residential decisions, where to live and what kind of housing arrangement you're going to have. So when you're thinking about guardianship and whether or not it's appropriate for you and your child, I like to take parents through kind of a thought experiment where you imagine your child as if they had no support whatsoever. So take yourself entirely out of the equation and put your child in, hypothetically in an apartment that they're unfamiliar with, and then imagine what their day would be like, what a week there would be like, what a month there would be like, right? So, starting with simple decisions like, are they going to manage their hygiene by themselves? Would they shower or bathe themselves independently without reminders from you? Do you need to insert yourself into that process, helping them physically or monitoring water temperature, things like that? You can go broader with, would they be able to maintain cleanliness of an apartment on their own? Would they be able to do the dishes and keep the refrigerator stocked with nutritionally appropriate food? Would they be able to prepare their own food? Those are the kinds of questions, you want to think about realistically what their life would look like without a bunch of support provided. You can also think about guardianship and its appropriateness in terms of those, big categories of decision making that I was talking about before. The easiest one to consider is medical decisions, because there's already a framework established by doctors that's called informed medical consent. That kind of lets you know whether or not you can make medical decisions yourself. So just imagine for a moment that your child's going to the doctor's office because they have a sore throat. The doctor might say, well, you've got, some particular kind of condition, maybe it's strep throat or something like that, and we could do A course of treatment, and that has these risks and benefits associated with it, or we could do B course of treatment, and that has a whole different set of risks and benefits associated with it. Is your child able to hear that information, process it, think about it rationally, and come to a decision? If the answer to that is yes, my child can do that, then guardianship, at least for medical decisions, is not appropriate. And we could consider some alternatives to guardianship that I'll talk about later. But on the other hand, if your child wouldn't be able to make those decisions themselves, let's say, for instance, that they would just say yes to the first thing that the doctor proposes, or, I have plenty of clients who would, just choose the thing that seems like it's going to involve the least amount of pain. Something like that. If your child is not making decisions for themselves in a rational way, then that's when guardianship is appropriate. Okay. When we're thinking about guardianship, the next question after you decide if it is appropriate is to then decide who's going to be the guardian. In your typical circumstance, where you might have two parents of the child that are still living and still involved in the child's life, it would be very usual for both of them to serve as guardians together, right? So you're actually both named as co-guardians. as you see on the slide, you can also have, for instance, siblings added as co-guardians at the same time. When parents and siblings are serving as co-guardians together, an important thing to remember is that they are co-equal. So the parents don't outrank the sibling. You all kind of have to make decisions together. So it's important to consider the family dynamic when thinking about adding a guardian, because you will have to work together, right? And that's a requirement that the court and the judge is going to impose on you. When thinking about a guardian when it's not obvious who the guardian should be, I've got a couple of things that you could consider. The first and probably most necessary piece of choosing a guardian is they have to have an interest in the individual that has a disability, right? I don't want to see parents I don't want to see guardians appointed that don't have contact with the individual that has a disability, or maybe, it's a second cousin that you're trying to choose because you can't find anyone else that's willing to do it, but that second cousin, sees your child once a year at Thanksgiving, and doesn't, follow up on your child's well-being throughout the rest of the year. That person is probably not going to be the best choice. You want someone that has expressed an interest and maintained a consistent interest in your child over the years, because when you're gone, that interest still has to be there, right? So that's something to consider. I also say that it's helpful if an individual lives close to the person that's going to have a guardian appointed over them. They're called the ward. That's not the be-all, end-all, though. I'd rather have a very interested individual that's going to put in the work to make sure that the ward is getting appropriate services that lives in Ohio than a person that lives down the block but really doesn't have an interest in your child's needs, right? So some of this would be pretty obvious if you think about it, but it's worth considering. There are also some nonprofit organizations that would be willing to serve as guardian, and there are also some government organizations that can serve as guardian if there are no guardians available. I usually think of these as a secondary resort, or in the case of the government organizations, a last resort. Not that there's anything wrong with the government organizations per se, and the organizations are the Office of Public Guardian and the Bureau of Guardianship Services, depending on the age of the individual. But the problem with those organizations is that, like many government organizations, they're underfunded and overworked, right? They don't have enough funding to take care of all the needs that they serve. So even though I think that they are full of well-intentioned and well-meaning people that are trying to serve the public the best that they can't always do a good job of it. So, I think that they are a good fallback position. And then there are also, like I said, some nonprofit organizations that would be willing to serve as guardian, but typically they're going to require that you have some funding set aside so that they can pay their employees and provide the services that they think are critical for your child after you're gone. Okay, let's talk about the process itself. So when thinking about the guardianship process, we've already gone through, is guardianship appropriate for your child, and then who should the guardians be? And now, assuming you've made it through and said, yes, guardianship is appropriate, and I'm going to be the guardian, here's how the process works. So, as I was describing before, at 18, your child is considered emancipated from your control, so you no longer have legal authority to act. And only a judge can appoint a guardian for an adult. Unfortunately, the way that the law works in New Jersey is that there's no way to make an application for guardianship in most counties before your child is actually 18. So they actually have to turn 18 and then you can apply for guardianship. As a result, this isn't a process that you can start when your child's 16. You basically have to wait until your child's almost 18. I usually say, 17 and a half, maybe 3 or 4 months before your child's 18th birthday is when I would recommend that you start working on the process and getting your paperwork together. As part of the process, there are several requirements. The first thing is that you're going to have to submit an application to the court. It's going to include those 3 items listed there, among a couple of other things. The important pieces here are, first, a verified complaint. A complaint is just the name that you give to the filing that you're making. A complaint is essentially just a list of reasons why you think that guardianship is appropriate for your child. So in that list, you might consider including things like, well, my child wouldn't be able to manage money, as applicable to your child. My child wouldn't be able to make medical decisions in their own best interests. My child can't manage his or her activities of daily living. Those are the kinds of things that the judge is going to be interested in, and the kinds of things that you would include in your complaint. Along with your complaint, you're going to have to get 2 certifications from doctors that essentially support your application for guardianship. In New Jersey, you could have the doctors either have to be MDs or DOs. So you can't, I get the question all the time about physician's assistants or nurse practitioners that, are the primary point of contact for your family for medical care. Unfortunately, those individuals can't fill out certifications, so you do have to get doctors to fill out the certifications. In lieu of one of the doctors, you could instead get a licensed psychologist in the state of New Jersey. Similarly, PhD individuals are accepted, so if you had like a psychologist or a neuropsychologist or something like that made a report or filled out the certification for you, that would also be fine. One kind of quirk with the doctor certifications that's supposed to be changing but isn't changed yet is an issue of timing. And let me just make sure I don't have it. Well, I do have this on a separate slide, so I'll talk about that in a second. The third thing that's included there is the affidavit of assets. That's essentially you just telling the court what kind of assets your child has. It has nothing to do with your own assets. The court doesn't want to get involved in those questions. It's just what assets are in your child's name at the time. All right. There is that recommendation that you meet with an attorney to draft your guardianship complaint and get your things filed with the court. This isn't strictly necessary. So if you're a highly organized person and you feel like you can tackle this on your own, you could, the place I would tell you to go is go to your county's surrogate court website and, maybe set up a meeting with the surrogate or the deputy surrogate in your county to talk about applying for guardianship pro se. We often in the firm talk about it kind of like a broken sink, where, if my sink breaks in my home, I can probably fix it. It's going to take me all weekend. It's going to take 10 trips to Home Depot, and I'm going to have bloody knuckles. But at the end of the weekend, I'll probably get it fixed. Or I could hire a plumber, right? And then the plumber is just going to do everything for me, and that's kind of the way I see an attorney's role in the guardianship process. It makes it easy and straightforward. I would highly recommend getting an attorney if you're in a situation where maybe your child is quote-unquote higher functioning, because then the question of whether or not your child needs a guardian could come up, and it'll be important to kind of phrase it appropriately to the court to make sure that the judge understands what's going on. So you can take all that for what it's worth. All right, so the timing rules. Like I said before, you can't submit before the 18th birthday. I will say that occasionally a surrogate court or a judge in a particular county might allow you to submit a couple weeks early. But generally speaking, they won't even look at an application, and they'll just send it back to you if you file it before the 18th birthday. A note on the doctors. They're supposed to, when they fill out the certification that I was describing on the last page, they're supposed to fill that out within 30 days of when the entire application, all of the documents, are submitted to the court. So you've got the example there. If your first doctor signs a certification on June 1st, everything, including the other doctor's certification, has to be submitted to the court by the end of that month. Another thing that a lot of courts require is that the doctors be from two different practices. So you can't have, and again, this varies by judge, but by and large, they're not going to let you have two doctors in the same pediatric practice or something like that be the ones to sign the certifications. They want kind of independent analysis from two different doctors. Okay. These notes here on this slide, there are certain changes that are made to the guardianship process or ways that are theoretically designed to make the process easier when you're dealing with an adult with developmental disabilities that is a client already of the Division of Developmental Disabilities, DDD. They allow a longer time period for the doctor certifications, and there is a tendency here to allow the use of IEPs instead of one of the doctor certifications. The problem with IEPs, and I have a number of issues with them. First, they have to be from within the last 2 years, which can be kind of difficult sometimes. If you're talking about an adult client, let's say you have a 30-year-old, there's no way that they had an IEP less than 2 years ago. The other problem with IEPs are just from an evidentiary standpoint. IEPs are designed to make the school district look good. And as a result, they often paint a rosier picture of an individual's capabilities than what is in fact reality. So IEPs are going to be focused on, look at all the wonderful progress your child is making. Look at all these skills that your child has mastered. And they're not going to be focused as much on, well, also your child still is incapable of managing their activities of daily living or taking care of their hygiene independently. So I often will see IEPs that have, that are only kind of tethered to reality. And if you just read them without any other medical documentation, you might get a different feel for your child than again, what reality has to offer. So I would just say with IEPs to be cautious about submitting them in lieu of a doctor certification if you fall within that parameter where you're able to do that. Okay. Now, once you submit all of your application paperwork, and one other thing I'll say about the application materials is that there are requirements to notify family members when you are applying for guardianship. So essentially, if you're applying for guardianship over your child, all the child's siblings who are over the age of 18 need to be notified, and in ideal circumstances, we would also get consent forms filled out by those individuals that says, yes, we understand that you're applying for guardianship and we're not going to oppose it, or we agree with it. Also, parents. So biological parents, unless the child was adopted, are entitled to notification. So in divorce situations, as long as the other parent, the other biological parent is still involved in the child's life, you can't simply decide, hey, I'm going to apply for guardianship. I'm not going to tell my ex-spouse or the child's father or mother. I'm just going to apply and get guardianship myself. You have to notify the other parent unless there's a safety issue or the other parent is simply not involved. I'll get cases where one parent comes into my office and says that the other parent hasn't been involved in the child's life since they were 2 years old or something like that. In those cases, you can just tell the judge as part of your complaint and say, hey, look, here's the situation. I don't want to have to notify this individual because maybe you don't even know where they are, or if they're still alive, or what state they're living in, and also they haven't been involved in the child's life, so their input into this process will not be valuable. All those things are up to the judge, right? So you kind of have to just be honest with the judge and then hope that they're going to make the right decision, which I will say that most of the time that they do. If you're in a situation where there are divorced parents or just two parents that are not cooperating together, it's very, very difficult for you to get guardianship sole guardianship as the only guardian over your child if there's another parent that is involved in the child's life that also wants to be a guardian. So, as unpleasant as it may be, if you're in a situation like that, my best advice is to have a conversation with the other parent about what you're planning to do and try to reach some agreement before you make your application to the court about, how you're going to make decisions together, or if only one of you is going to be the guardian and not the other one. It's really important to get out ahead of those issues because you don't want to end up in a situation where you're having a full trial about who should be the guardian, because that can become very time-consuming and expensive if you're represented by a lawyer. Okay, so we've got all the application materials in. What happens next? Essentially, the first thing that the court is going to do is they're going to set a hearing date, which is a date that you may or may not have to show up to court for. And they're going to appoint a lawyer to represent your child, the individual that has a disability. That lawyer's job is to represent the wishes of the individual with a disability, unless those wishes are absurd or they pose an undue risk to the individual themselves. So to further this goal, that court-appointed lawyer is going to want to come to your home and is going to want to meet with you and meet with your child. To the extent that your child can express their wishes, the court-appointed attorney, again, has to take that into consideration. But, I get questions a lot about, maybe your child presents fairly well, but, surface-level meetings, superficial conversations are all that they can manage, and if you dig deeper, it's clear that they need additional support and they need a guardian to make decisions for them. I can tell you that in those circumstances, my experience is that most court-appointed lawyers get those questions right. They understand. These lawyers are typically appointed multiple times by a court, so you will very likely not be the first family that has a special needs individual in it that the attorney has met with. So they should be somewhat sensitive to special needs issues. And they're just people. The other thing to remember is, no one really wants some strange lawyer to come to your home, and I get that. But also, they're just a professional, they're just an individual, they're a regular person, and they're just trying to do their job. So, be courteous to them, but also they'll likely be charging you. So there's no need to be overly familiar. Just answer the questions that they have, and 99 times out of 100, everything is fine. Okay. I also did make the note that parents in most counties are responsible to pay the court-appointed attorney fees that are usually based on their hourly rate. Okay. All right. So once everything is submitted, and the court-appointed lawyer will write a report that they submit to the judge. The judge is then going to review all of the information and determine whether or not to hold an actual in-person hearing. If a hearing is decided to be necessary, some judges now are just saying, regardless of the case, I'm going to require everyone that wants to be a guardian to show up to a hearing in person. And there is, I will say, a lot of pressure from the state to have judges do that. So even judges that historically weren't requiring people to show up are now starting to require people to show up to a guardianship hearing. This isn't something you're going to be able to fight. If the judge tells you have to show up, you have to show up, and that's kind of the end of that. Unless there's some issue that has been identified in advance of the hearing. So unless someone is contesting it, I was talking about divorce situation earlier, unless there's a contest of some kind, if everyone's in agreement that guardianship is necessary and we know who the guardians are going to be, these hearings are generally very short, maybe 5 or 10 minutes, and are just a formality. It's not something that you should be overly concerned about showing up to. Obviously, if there's a contest, if someone is objecting to the guardianship in some manner, those hearings become critical, and that's where you're going to present evidence and provide testimony. That's kind of outside of the scope of this overview, but it's something to be aware of. Now, in some counties, the judge will decide that an in-person meeting is not necessary, that they can make a decision based on the papers that were submitted, and in those cases, they'll still have a hearing date, but they won't make you show up. They'll just sign the forms, they'll sign the order, they'll send it out to you. Here's a critical piece. After you get the judge's order, you still have a little bit of work to do. You're going to have to do what they call qualifying for guardianship, which essentially is you just have to show up to the surrogate court office in your county, present the surrogate with the judge's order, and usually they require some form of identification, and they're going to issue you what are called letters of guardianship it's going to be a piece of paper 8.5 by 11 that has a raised gold foil seal on it. That document you never want to get rid of. You always keep that safe. You don't give that away to anyone, although you can give copies to people. They will also issue you what are called guardianship short certificates. Now, these guardianship short certificates in most counties cost $5 a piece, and you can get as many as you want whenever you want them. So I typically recommend that parents get maybe 3 or 4 to start, and then just ask for more from the surrogate court as needed. Okay. All right. So let's imagine that you get the guardianship. You've gone through the process. You've decided it's appropriate. Now what do you do? Essentially, the guardianship is responsible to make decisions for the individual that has a disability. And usually we're talking about major life decisions. The decisions have to be made in the best interest of just the individual with a disability. So you can't make decisions. I mean, this is probably obvious to parents, and this is the way that parents act anyway, but it's important to note, you can't make decisions based on the best interest of the entire family or of you as the parents or what's most convenient. It has to be the best interest of the individual that's under guardianship. Now, that said, it's important to think about guardianship as kind of the person that's appointed as a guardian gets the final say. They get the final say on decisions. But that doesn't mean that the person under guardianship can't make any decisions at all. They can make whatever decisions that the guardian believes is appropriate for them to make. So, you should imagine it as not being much different than being a parent of a minor child. So let's say you have a 14-year-old that's typically developing. You might say, well, here's $20 and you can manage it however you want. But you wouldn't say to the same 14-year-old, here's $2,000, you can manage it however you want, right? So it's the same kind of thing with guardianship, that you can decide what level of independence is most appropriate and in the best interest of your child, and allow them to make decisions inside that scope. But still, you are ultimately responsible for the major overall decisions. Okay. All right. Now, I get the question all the time about successor guardians. There's no way in New Jersey, outside of some fairly rare circumstances, to select a successor guardian in the court. So you can't say, well, I'm mom and I want to be the guardian, and then when I'm dead, or if I'm incapacitated, I want, my daughter Susan to be the guardian. A judge is not going to approve that. Either they're going to appoint you and Susan together as guardians right now, or not. And they're not going to say, well, it's you and then Susan. What you can do is name a successor guardian in your will. So if you're appointed as a guardian, you can say, in your will, I'd like so-and-so. In my example, Susan. I'd like Susan to take over as guardian when I pass away. The thing to note is that this appointment in your will doesn't happen automatically. The person that you appoint in your will still have to make an application to the judge and say, I want to be the guardian, and the judge has to sign an order saying that, right? Additionally, if you are aging as a parent and you're the guardian, you can choose to add additional co-guardians at any point in time. So, it happens often that I'll have two parents in their, let's just say 50s, that get appointed as guardians together, and then maybe 20, 30 years later, they're in their 70s or 80s, and they say, well, this is a big responsibility. We want to ensure a continuity of care for our child, so we're going to add, maybe one of their other children as a co-guardian to serve along with them, or as a substitute guardian to serve instead of them. That would make it so that there's a continuity of care. There would never be a point, if you did it that way, at which there was no guardian appointed. Whereas if you waited until you died and then said, I want so-and-so to be the guardian, and you just had that in your will, there will be a period of time from when you die until the next guardian is appointed. All right, so that's just an important thing to remember. Okay, so that's the guardianship process in a nutshell. I want to touch just briefly on some of the alternatives to guardianship. The first is limited guardianship. Now, limited guardianship follows the exact same process that I've already outlined. And you do the same kind of thought experiment, and you say, well, what are the decisions that my child is capable of making, and what are the ones that my child is not capable of making? Limited guardianship is appropriate, particularly in circumstances. The easiest circumstance to describe would be someone who is, quote unquote, very high functioning in some areas and then very low functioning in other areas. So I'll just give you an example. I had a client who was diagnosed with autism, who could have, erudite conversations with me about politics and religion, and, had great ideas and strong thoughts about what he wanted to do for work. So guardianship of him that was full, that related to kind of every aspect of his life, wouldn't have been appropriate. But at the same time, he was incapable, he had no number sense. He was incapable of, even simple addition and subtraction. So in that circumstance, we were able to apply and get limited guardianship over just his financial and medical decisions. So with limited guardianship, you can essentially carve out areas of decision-making where you think your child needs help, and then leave alone the areas where they can make decisions for themselves. I do have to stress that it's important when you're thinking about limited guardianship to really have a realistic understanding of your child's capabilities and limitations in these decision-making areas. I could go through some examples of parents that applied, just for limited guardianship without really considering what that means for their child, and then their child ended up making, very poor decisions in the areas where they didn't have guardianship authority. And so they had to actually go back to court to get authority to kind of correct what their child did. So, and I don't say any of that to scare anyone. It's just, you really have to start in that thought experiment that I was describing at the beginning of this conversation with realistic assessment of what your child would be capable of without any support. Now, the other two alternatives are conservatorship and power of attorney. Conservatorship, very briefly, is essentially a situation where you just take control of an individual's assets, right? And it's actually a consent relationship where the individual says, yes, I agree that I need help with these assets, and I'd like to appoint, let's just say, for instance, a parent, my mother or father or both of them as a conservator. This is relatively rare. In most cases, conservatorship is better utilized for like an elderly individual that has a lot of assets but doesn't, have the wherewithal to manage them all anymore. So maybe they still understand what their assets are and where they're held, but they don't want to go through the rigmarole of kind of paying their bills every month and keeping track of their asset allocations. That's when a conservatorship is particularly helpful. In cases with individuals with developmental disabilities, I'm usually seeing more of a need for either a limited guardianship or some other arrangement. Now, with a power of attorney, there are essentially two documents there. You can get a power of attorney that covers financial decisions, and you can also get one that covers medical decisions. Those are often called living wills or medical directives or healthcare directives. Those are all essentially the same document. We consider guardianship and powers of attorney to be what we call mutually exclusive. So either guardianship is the right way to go. And again, guardianship is the right way to go when your child can't make decisions for themselves. Or a power of attorney and a medical directive is the way to go. And that's appropriate for basically anyone else, right? So typically developing adults should have powers of attorney and medical directives when they're 18, Everyone listening to this webinar should have a power of attorney and a medical directive that appoints someone that's able to make financial decisions for you or medical decisions for you in the event that you can't make those decisions yourself. Let's say, for instance, that you're in a car accident and you're in the hospital, you still have to pay your bills. You still have to keep the lights on at home. You still got to pay your mortgage. So those kinds of things are what a power of attorney and a medical directive allow you to do. Again, in order to make those documents, the child has to understand what's going on. They have to understand the decisions. They have to understand what their assets are, how they're held, and those kinds of things. So, either guardianship is appropriate or a power of attorney is appropriate. You can't, in only extraordinarily rare circumstances could you ever have both. All right, so that's an important thing to remember. Now, with a power of attorney, that's not a process that has to be approved by a court. You simply, apply. You simply talk to a lawyer usually, and have them draft up a document, and it gets notarized, and then it's in effect. Okay. I've got slides on all of these. So I did already talk about limited guardianship and when it's appropriate versus plenary or full guardianship. So, again, it's the same process. It's just that the overall result is, you would have decision-making in some areas, and then your child would have decision-making in other areas if you went with limited guardianship. I also talked about conservatorship, so I won't belabor that point. Okay. Powers of attorney. I already described this as well. One other thing that I want to just kind of really nail down the difference between power of attorney and guardianship is that with a guardianship, the ultimate decision maker is the guardian. So, in a very concrete example, let's say that you're the guardian of your child and you go to the doctor's office to get a flu shot, and your child says, I don't want a flu shot. You can decide as a guardian, well, no, it's in your best interest to get a flu shot. I know it's going to be painful, but we're going to get one for you, right? So in that circumstance, if you're the guardian, you get to make the decision. If you only had a power of attorney and a medical directive, and you're in that exact same circumstance, your child's wishes are the ones that govern. So your child could say, no, I don't want I don't want the flu shot, and you can't kind of overrule them in that circumstance. They are the decision maker. Okay, that's guardianship in a nutshell. I want to kind of switch gears and talk a bit about adult services for individuals with developmental disabilities. Essentially, the only game in town that is really of any help at all is the Division of Developmental Disabilities, which is DDD. All right, they provide services to individuals who have developmental disabilities that are over the age of 21. Right, so before 21, essentially DDD says, well, the school's providing the services that the child needs, so we're only going to step in after 21. DDD also now has a requirement that anyone receiving their services has to be Medicaid eligible, right? So you have to be receiving Medicaid services in order to get DDD services. So the remainder of this, talk today is going to be about, well, how do we get access to Medicaid, not only for the benefit that Medicaid offers in and of itself, but really for then in turn accessing DDD services, right? So you need to have the Medicaid first before you apply for DDD. I can't stress that enough. So the 10,000-foot view here is let's get Medicaid and then let's get DDD services. All right. Now, DDD does require you to have a developmental disability that substantially impacts 3 of 7 categories of major life activity, right? And you've got the 7 categories listed out for you on the slide. Some of these will dovetail with each other. Nothing, there's some examples you might think of that kind of affect multiple of these categories. But an easy way to think about DDD eligibility in terms of these categories is also to compare it to guardianship. So we were talking about, your child's ability to make decisions for themselves. That falls squarely under self-direction. The ability to make a decision for yourself in major areas of decision-making. If they're not capable of it, if you have someone that the court has said has been adjudicated what we call incapacitated, that's what you get when when a guardian is appointed, that is the court saying this person lacks the ability to self-direct and make these major life decisions. We could look at self-care. That's really about activities of daily living. Can you maintain your hygiene? Can you maintain, your diet appropriately? Those kinds of things. The other ones are fairly self-explanatory. A learning disability, that's fairly obvious. If your child has an IEP and they require substantial assistance or they're getting modified curriculum in classes, that goes towards learning. So all of those categories, you have to establish the substantial functional limitation. The kinds of services that DDD offers. The big ones are day programming and residential services. Day programming is essentially, you could think of it like school after school, right? So once the educational entitlement ends, you're out of the public school system. They're not going to provide you with any more programming. But DDD can step in and provide a day program which is going to be made up of, basically exclusively of individuals that have developmental disabilities. And day programs can look like a bunch of different things. They could be more skill acquisition based, where it looks more like school. It's not going to look exactly like school, but it could look more like school. Or you can have a program that's just about community involvement and, socialization opportunities, where they're getting out, they're going to bowling, they're figuring out how to make purchases, those kinds of things. So day programming is good. You also get transportation to and from day programming. So, you could even have DDD, you could pick up your child right at your house, transport them to a day program, and then bring them back at the end of the day. Residential services is the other big one. Residential services, we're talking about group homes here for the most part, although there are also things like supervised apartments and some other housing options, which I could certainly talk about, but that's a bit outside of the scope of what we wanted to cover today. But, residential services, it doesn't have to be something that you're looking for right this second. I mean, you could say, hey, Adam, I don't want my child living outside of my home while I can still provide for them. That's fine. But you should be thinking, even at this early age, even at 18 and even younger, that if your child outlives you, they're going to need someplace to live, right? So, in the likely event that you die before your children, you've got to be thinking about, well, what's their living arrangement going to be? And for a lot of people, DDD, getting residential services provided by DDD is going to be the only real option for you. Okay, so that's the overview of what services DDD has. Now let's talk about how you get Medicaid so that you can get access to those services. Now, the easiest way to access Medicaid is a program called SSI, Supplemental Security Income. Now, this is a social security program, which is associated with not only Medicaid eligibility, but also a cash benefit. And I'm going to be talking about that in more detail on the next slides. There's also age, blind, and disabled Medicaid, which is a Medicaid-only system for individuals that are over the age of 65, or they're blind, or they have a disability within the definition of the Social Security and Medicaid Acts. So that's a Medicaid-only program. Some of you may be familiar with New Jersey Family Care, which is an extension of ABD Medicaid. Right? There's also a Medicaid program called Workability. Workability is a program that allows individuals to work while still getting Medicaid, and they can, I'll be talking in greater detail about the income and asset thresholds for Medicaid and Social Security, but Workability is a great program to keep in mind if you're thinking that your child's going to be capable of doing some work, but still not supporting themselves entirely. Okay. And then disabled adult child, I'll get into as I talk about Social Security because it applies only to Social Security benefits. Okay, so let's start with SSI, Supplemental Security Income. SSI we often call the front door into Medicaid because if you get SSI in New Jersey, you'll also automatically get Medicaid services without having to do a separate application. Now, what SSI is, what Supplemental Security Income is a cash stipend that's given each month to your child. It's typically a cash stipend of between about $500 and about $700 a month, and I'll talk about how to maximize that benefit. But it's a cash benefit, and then again, if you get that cash benefit, you get Medicaid automatically, and that's what we're really driving towards. So here are the eligibility criteria for SSI. It's essentially three things. One, there's an income test. Two, there's an asset limit. And then three, there's a disability test, right? When we're thinking about these limits, typically an individual, well, let's just break right into them. So the easiest one to talk about is the income limit. The slide says approximately $780 per month in total income. It's actually a limit of about $981 per month total that your child can earn gross income in a month. As long as your child's income is under that limit, then you meet this first test, right? You're within the income criteria. It's important to note that if your child is over the age of 18, this income limit is based only on your child's income and not your income as a parent. and it's going to be the same thing with the asset limit. Before your child turns 18, the income and asset of parents are considered attributable to the child to a certain extent. So, what that essentially means is that most individuals won't be eligible for SSI until they turn 18. In some cases, if you have a single parent that, not a dual income household, you might be eligible. Your child might be eligible to receive SSI before the age of 18. But those criteria for individuals who are under 18 are much more complicated and kind of not the subject of today's discussion. Okay, so we've got the income limit of $981 per month. We've got an asset limit, so your child cannot have assets in their name over $2,000. Now, Social Security counts virtually all assets, right? So if you have an account that's you set up and it's in your name and your child's name, they're going to consider all of the assets in that account to be attributable to your child. So even if you were the only one that put money into it, or maybe it's funded with birthday money from the last 18 years of your child's life, none of that matters. If your child's name is on it, they're considered an owner, and they have access to all of the funds, right? So another thing that often gets people in trouble is something like savings bonds. Let's say grandma gave you a bunch of savings bonds for your child when your child was born, and then you put them in a safe deposit box and forgot about them until I just mentioned them a second ago. All right, so I guess my audio cut out for a bit, so I'm just going to recap the SSI eligibility criteria quickly. Essentially, the main points to remember are that there's an income limit of about $981 per month that your child is allowed to earn before they and still be eligible for SSI. There's an asset limit of $2,000, so anything in your child's name which accumulates over $2,000 is going to make them ineligible for the SSI program. And then the third criteria is that your child has to have a disability. All right, and the way that Social Security defines a disability is that they say that you have a disability within the meaning of the Social Security Act if you are unable to engage in substantial gainful activity. Essentially what that means is if you're unable to work in a competitive work environment, right? So when Social Security is considering disability criteria, the big thing that I like to tell parents is, when you make your application, you have to make sure that you are providing enough information to Social Security so that they can make an independent determination that your child does indeed have a disability that prevents them from working. I always tell parents to kind of come loaded for bear. Have all of your medical evidence together as part of your first application. Now, when I'm talking about medical evidence, what I don't want to see is, a letter from a doctor that says, for instance, Tiffany has autism. I've been treating her since she was 10 years old. She's on the following medications, XYZ, and therefore she should be eligible for Social Security benefits. That means absolutely nothing. Social Security is not all that concerned with a diagnosis as making you eligible for benefits. Social Security's test is a functional one. They want to know if you're capable of working, or if your child's capable of working. So what you should really be diving into, and if you get letters from doctors, which I think is very helpful, the doctor shouldn't just say your child has autism or Down syndrome or whatever, and therefore they should be eligible. The doctor should say, Tiffany has autism. As a result of her autism, she's incapable of following multi-step instructions. She needs to be redirected to task. She doesn't understand social situations and wouldn't understand the hierarchy of employment, working for a boss or an authority figure. Essentially you're trying to include specific symptomology of why your child would not be able to engage in competitive employment. All right, so that's really an important piece. Again, I was talking about in relation to guardianship applications, whether IEPs would be appropriate. Again, you want to make sure that you have all the evidence submitted with your initial application to allow Social Security to determine that your child has a disability. If you're submitting doctor's evidence or doctor's letters, you want to make sure that they're not just saying your child has a diagnosis and therefore is eligible. You want to say, here's the diagnosis and here's all the symptomology and all the reasons why your child would be incapable of competitive employment. I want to caution you about submitting an IEP unless it's directly asked for, because a lot of times IEPs just don't paint a good picture of reality. They don't give you a good understanding of the student's needs. The other things that you could consider supplying are triennial evaluations. So if the school district performed, a psychoeducational evaluation in the last couple of years, that can be helpful evidence, because a lot of times there'll be some kind of IQ test and some other functional tests that can give Social Security a better idea of what your child's limitations are. The other thing that you could consider is first a narrative. So you can supply a narrative of, this is what my child's day looks like, these are the kinds of things my child needs help with on a day-to-day basis. And you could also submit letters from previous employers. So if your child ever tried to have a job, maybe working part-time, or maybe your child works with a job coach in your school, someone that has seen an attempt at employment can certainly be helpful in guiding Social Security around what the issues were related to, independent operation in an employment environment. So those are the big things that you should be thinking about for the eligibility criteria. Okay. So again, if you get SSI in New Jersey, you also get Medicaid automatically. There's nothing else that you have to do or apply for. Okay, now this is age blind and disabled Medicaid. It's kind of the second way that you could apply for Medicaid outside of the Social Security system. So let's say that you couldn't meet the Social Security requirements for some reason. You can still apply for ABD Medicaid. You do it by applying directly to the County Board of Social Services. The asset limits, as you can see there, the income and asset limits are slightly different than under the Social Security SSI application. They're slightly more forgiving, so you can see the asset limit's $4,000 and the income limit is about $1,041. I think that was recently put up a little bit higher than that, but that's a general guideline for you. So, long story short, an application like this could be easier. Let's say you get denied Social Security for whatever reason. You could still get Medicaid outside of the Social Security system, and sometimes it's a little bit easier to do it that way. Okay, the other program is workability. So like I said, workability is really for individuals that are capable of working or have some kind of work income, some earned income from work. But maybe it's not necessarily in a competitive work environment. So they're not real, so they still have a disability, but they are, they have been given an opportunity for employment kind of despite the disability, right? So it's not a competitive opportunity. The easiest way to describe this is with an example. Let's say, for instance, I've had a client who was a librarian in a county library, and her daughter, worked with her in the library, restocking and things like that, but it was under her direct supervision. So, her daughter made a decent salary, but wouldn't have been able to hold that position without the kind of constant support and guidance that mom was giving to her throughout the course of the day. So, we were able to, that's a kind of quintessential example of a person who would fit well within the workability requirements because, she was earning, I think it was roughly $30,000 a year or something like that. working full time, but again, because it wasn't competitive, we could still establish that there was a disability within the meaning of the Social Security Act. Workability, like ABD Medicaid that I just described, you apply for workability by simply making an application for Medicaid at the County Board of Social Services. If you're considering workability as the primary thing that you're going for, if you know you're not going to be eligible for the other programs that I've been talking about, then you should make sure to write something on the application that says, you specifically want to be considered for workability, because one of the major pitfalls that I've seen with these applications is, they simply don't get to the right desk, and, some worker will just look at it and say, well, you're not eligible for Medicaid because you have over $4,000 in assets, or you have over $1,041 in income per month. And then they'll just reject you even though you could have been eligible under the workability program. So that's just a practical piece of advice. Okay, so we got a little technical interruption again. I'm just going to recap that we're talking about workability. And workability has, still has income and asset restrictions, so you can make up to $60,000 approximately per year in earned income. And you can't have more than $20,000 in what they call liquid assets. So this asset test is slightly different than SSI's test that we were talking about before, because it doesn't include assets like the value of your home, the value of your car, the value of any retirement plans that the individual has. So if they have a 401k or an IRA or a Roth or something like that, none of those count towards the $20,000 asset limit, just for the workability program, and I want to stress that. So, the workability program is a good workaround for individuals that want to work and get an opportunity for employment that is supported, but still require Medicaid and DDD services in order to function and support themselves. Okay. Now we want to talk about disabled adult child criteria. It's essentially the DAC status is a status that is given to you from the Social Security Administration in certain circumstances. And essentially, this DAC status, if you get it, and I'll describe how you can get it, would enable you to apply for Medicaid at the county level, like I was describing before with ABD Medicaid, and still receive Medicaid benefits even if your child is making too much money from the Social Security Administration based on your work history. So let me dive into the details of this. Essentially, an individual with a disability, if they meet the disability criteria, is entitled to receive benefits based on a parent's work history. But they only start receiving those benefits when either the parent becomes disabled themselves, the parent starts collecting Social Security based on retirement, or the parent dies. Right? So under those three situations, a person with a disability can collect under their parent's work history. So it often happens that an individual will be, at 18 years old, will apply for SSI, like I was describing before, and receive the SSI benefit for a certain period of time. And then when a parent, again, either dies, becomes disabled themselves, or retires, then the individual will be entitled to receive a benefit based on their parent's work history. And that benefit could be great enough, could be large enough, that it kicks them out of the SSI program. So let's just say, for instance, that Tiffany is the person with a disability. She's getting SSI at the age of 18, and then sometime later, let's say she's 30, and her father decides to retire. When he does that, she will then be entitled to receive a Social Security benefit based on her father retiring, And if that benefit was, let's say, $1,000 a month, then that's over the SSI income limit that we were talking about before. So Tiffany would lose SSI. And then, parents will often panic at that point because the SSI benefit was how Tiffany was receiving Medicaid. And again, Medicaid is required to get DDD services. So, essentially that one move could place everything in jeopardy. However, if you're in that situation, Tiffany would get this status that's called DAC status, Disabled Adult Child Status. And essentially the only thing you'd have to do if you face this situation is to then take that status that'll be given to you by Social Security and then apply for Medicaid at the County Board of Social Services in your county. And what Medicaid does is essentially ignores the income that Tiffany is receiving based on her parents' work history. So, that $1,000 a month then is not counted against her for Medicaid eligibility, right? So in the vast majority of circumstances, when a parent retires and a child loses Medicaid through the SSI program, we can reestablish Medicaid eligibility at the county level because of this disabled adult child criteria. So really the takeaway here is, if you're in that situation, you should just know that there's a way out of it, that you can still receive services, that you can still get Medicaid and DDD benefits. Okay. This kind of touches on what I was just talking about, but also you should note that if your child is receiving benefits based on, a parent's work history, so if a parent is receiving their benefits, then the child can also get Medicare in addition to Medicaid after 2 years of receiving the benefit. So, that's just an important thing to note, that it's not a problem. You can have private insurance plus Medicare plus Medicaid, and in most circumstances, there usually isn't a difficulty with coordinating those benefits. Sometimes you'll run into some scenarios where it can become an issue, but by and large, having additional health insurance coverage is not an issue. It's not a problem. Okay. Now, switching gears a little bit. Let's say that you establish Medicaid. Now I want to talk about DDD and a particular program called the Community Care Program. All right, so I was talking about a bit earlier about the DDD application process and what their criteria are. Assuming you become eligible for DDD, and you're going to have to go through, it's a fairly lengthy application process that you can start undergoing anytime after your child is 18. I typically do strongly recommend that you start it before about the age of 20, because it can take 6 to 8 months, and you don't want to have a situation where you're not yet considered eligible for DDD, but you've been pushed out of the school system, the public education system. Okay, so when you apply for services from DDD and you're applying for eligibility for DDD, the important thing to remember is, much like that thought experiment that I had you do for the guardianship application, you should imagine your child, when you're answering questions, as if they had no support whatsoever. So, if they ask you a very vague question like, can your child shower independently or something like that, or take care of their hygiene. If you say, well, they are independent, I don't have to physically assist them, but I have to remind them, I have to give them prompting, or my child only engages in a hygiene routine because I have established a routine over the course of years, and if you removed your child from the routine, that they would fail at maintaining their hygiene, then the answer, quite simply, to the question, is your child independent in this category, would be no, they are not independent. So it's important to recognize, to try to remove yourself and any support that's offered to your child from the equation, and then answer the questions that are asked. Now, the CCP is the Community Care Program. It's essentially the way, this is fairly complicated, but it's called a Medicaid waiver. And it's a way that the state of New Jersey is able to pull down federal Medicaid dollars to pay for certain services. The big one with the community care program is residential services. So, over 90%, and it may even be fairly close to 100% of the individuals that receive residential services funded by DDD are on the community care program. You can make an application through DDD. That's how you get access to it. There are waiting lists associated with the community care program. DDD is trying to get away from these waiting lists or work through the waiting lists more quickly. But they haven't completely gotten rid of them. You are entitled to kind of jump to maybe not the front of the line, but to a priority waiting list if you're a parent and you're over 55 years old and your child is living with you. There are also exceptions, and I think that this is one of the big things to keep in mind for residential placement, essentially for the safety of a child. So if the child is unsafe at home, either due to your changing needs, as a caregiver, if you're no longer able to meet the needs of your child, or if your child's needs are so, what you might call extreme, or that they need additional supports that you can't offer them in the home and maintain their safety at home, then you can get eligibility for the community care program and residential placement and bypass the waiting lists that I was describing. So, they typically refer to this as an emergency placement, and there are some rules and regulations surrounding that. The big takeaway that you should just remember is that it is an option to overcome these waiting lists if you can demonstrate an immediate need for residential services. Okay. So this is kind of just more on the immediacy of the need. Essentially, they call it an emergency residential placement. If you need that, it's a high bar to meet, so it's not going to work for everybody. But, if you're in a situation where you absolutely need residential services for your child, there is a way to bypass all these waiting lists and things like that. And so that's the big takeaway that I want you to have. Okay. The residential services that DDD offers, I kind of talked about them a little bit before, but primarily we're talking about group homes, which are, places that typically have 4 individuals approximately living in the same home and all receiving services. There are also supervised and supported apartments. Those are some options for residential services. And then there are self-directed budgets that you can get and use for services that you provide in your home. All of those kinds of things are going to be things that you have to work out with DDD after you get that eligibility determination. And again, just as a second, as maybe the 15th time I'm reviewing this, in order to get DDD, you got to first have Medicaid, and then the easiest way to get that is through SSI or some of the other applications that I've already talked about. Okay, the last thing that I want to talk about with respect to adult services is vouchers, which are fairly new in terms of providing residential options for individuals with disabilities. The first and most well-known is the HUD Section 8 housing voucher, which is essentially, it's called the Housing Choice Voucher Program. Under this program, there is no disability requirement. It is simply a means-tested program where you have to meet certain income and asset limits, just like all the other programs I've been talking about today. But if you get in the program, then essentially the federal government subsidizes your housing. You only have to provide 30% of your income, whatever that income is. If it's $0, then you only have to provide $0. If it's $1,000, then you got to provide, $333. Or whatever that 30% comes out to. And then the government provides the rest. With these vouchers, you have to go to a landlord that accepts the vouchers. So, it's a situation where you can't just take this anywhere. And there are restrictions on cost of different apartments and things like that. If you get one of these Section 8 vouchers, I'll tell you that the biggest hesitance I have about recommending them to people is not the service or the way that they're run, but simply that it's just notoriously difficult to get one of these vouchers because you don't have to establish a disability, so anyone with limited income and assets can apply. So oftentimes there'll be application windows of only a few days where you have to get your application in, and then you're entered into a lottery, and then if your name is selected, you get one of these vouchers. There are new vouchers in New Jersey that are called the State Rental Assistance Program, or SRAP, that operates very similarly to the HUD Section 8 voucher program. But New Jersey's distinction is that they set aside a certain number of these vouchers just for individuals that have a disability. So it's much easier to get a voucher through the State Rental Assistance Program than it is to get selected in the lottery for Section 8. Again, if you're, once you get DDD eligibility, DDD caseworkers and actually your support coordinating agency is going to be able to help you kind of navigate applications for vouchers like these. Okay. There are other assistance programs out there. There are some energy assistance programs that help you pay for utilities, and there's SNAP and food stamps and things like that. None of them are as huge or impactful as the benefits that I was talking about today, and a lot of them have other kind of extraneous rules that are specific to just those programs that can sometimes make them more of a hassle than a benefit. But it's just important to know that there are some other programs out there that you could get the assistance of. One that I'll just mention quickly is the Personal Preferences Program. It's called PPP. It's a Medicaid program where you can get additional services beyond what DDD is offering you in-home. So if you needed like nursing, private duty nursing or something like that, or you could actually get paid yourself for caregiving that you're offering to your child, that you're providing to your child while they're living in your home. So, just an important thing to be aware of. All right, so I've been talking for a while. I hope that you've gotten some valuable information out of this. I will end there today, and I thank everyone for the opportunity and for your attention.
So I'm going to transition in 3, 2, 1.
Thank you, Adam, for that valuable information. We're going to go ahead and take some time for questions now. So just a couple of reminders. Please feel free to type your questions into the chat box if you have any, and don't forget to fill out our evaluation at the link provided in the chat box. Okay, I think we have time for a couple of questions. Let's see. Adam, could you comment on whether there are any low or no-cost options for completing the guardianship process? Yes, I'm there on DD. Okay. Adam, can you hear me? This is Jill. Okay. Adam, did you hear my question? Oh, okay. Oh, I'm sorry. Okay. So the question that came in was whether there are any low or no cost options for completing the guardianship process for a family. Thank you. Another question that came in is, what is your best advice for practitioners for beginning the transition process with their clients or patients? Right. Well, especially service providers like physicians, nurses, mental health providers. Okay, thank you. Here's a question that I think is very important. It's a little complex. So this is from a parent that says, I find the system to be very confusing. My daughter has just turned 21 and will be aging out of the program that she's in very soon. She is on waiting lists, and I really feel as though we're dropping off a cliff. I've looked at multiple programs, both good and bad. If programs are not available, what options do we have for spending their budgets in order to get a program or create a program? Okay. Actually, a follow-up to that was that the parent said, would he or she be able to hire a direct service provider in order to, in a sense, create a program? Okay, thank you. A different question came in about parent is saying, how will my son spend his day after the age of 21 if he needs supervision? So I think this question is somebody is going to be graduating from school, and it sounds as if there's not a program in place. So, thoughts?
eligible to start the process around 18. For a family that's already at 21, the only thing that you can ask for is for them to expedite and try to work quickly. And depending on your situation, you might be able to get some kind of emergency placement, although those are kind of difficult to come by.
Okay, thank you. So it looks like we're out of time. I want to thank everybody and our speaker, Adam. We appreciate your participation. The next NJACE webinar is going to be on July 23rd, and the topic is Transition to College Programming. So please feel free to sign up, and don't forget to fill out the evaluation form. And thank you all so much for joining us this evening.
Thanks very much for having me.